Hey everyone, I'm David Finz, and on this episode of the Cyber Insurance Imperative, we're going to discuss a major development that creates new opportunities as well as challenges for American companies that conduct business with European consumers. This past week, the European Commission issued what's known as an adequacy decision for the EU's data privacy framework with the United States. This means that the Commission has decided that the U.S. offers an adequate level of protection for data transferred from the EU to the U.S. under its data privacy framework. This decision follows the White House having issued an executive order enhancing safeguards around American intelligence gathering activities, addressing concerns raised by the European Court of Justice in its 2020 ruling known as Schrems II. These new safeguards are meant to limit such activities to what is necessary and proportionate for U.S. national security and to provide an impartial method for resolving data privacy complaints by European citizens. So why is all of this necessary? Well, GDPR has strict requirements around the transfer of personal data from the EU to other countries. In a nutshell, the other country must have data protection standards that are comparable to that of the EU, and the Commission determines this by issuing an adequacy decision. As a result of this decision, data can be transferred from any public or private entity in the 27 member states covered by GDPR to U.S. companies participating in this data privacy framework. Under this framework, residents of the EU have several new rights, including the right to obtain access to their data, to correct errors in their data, and to delete data that has been improperly collected. The framework also offers a dispute resolution process that is free of charge to individuals who wish to bring a complaint. U.S. companies who wish to participate in this framework must commit to compliance with a detailed set of privacy obligations. These include limiting the scope of the data collected, the purposes for which it is used, and certain requirements around data security and the sharing of information with third parties. The U.S. Department of Commerce will review applications from American businesses for certification under this framework, and compliance will be enforced by the Federal Trade Commission. So if your business plans to collect data on EU residents, you're going to want to make sure that your safeguards are in compliance with this data privacy framework. The first step is to get in touch with qualified privacy counsel who can review your current practices and make recommendations for certification. Need a referral? Please don't hesitate to reach out. You can DM me on LinkedIn or email me at david.finz@alliant.com. And I'll be happy to put you in touch with several qualified law firms that you can vet for yourself. You're also going to want to make sure that you have the broadest possible coverage for regulatory proceedings, and Alliant can review your current policy wording to ensure that you are leaving nothing on the table. And if your current insurance broker isn't having conversations with you about this new data privacy framework, maybe it's time that you discover the more rewarding way to manage risk. Thanks for watching.